Welcome to the last day of the conference. We prepared the best beats for the end, so those that are in the room right now, you're going to enjoy a very nice discussion about how, in the international context, financial, political influences what happens within the countries in constitutional terms or legal terms. And we're going to start with Becket Bedford, who is a human rights barrister, member of the Honourable Society of the Middle Temple in the UK. So he comes from practice, and he's going to talk to us about the Euro crisis, a crisis of belief in the rule of EU law. So about the most recent developments in the UK in view of EU legal measures. Please, Becket.
Sure. Well, thanks very much for the introduction, Dana. And it's a privilege to be here. So the backdrop to the talk is the collapse of the American banking system, which led in turn to the collapse of our own banking systems and the sovereign debt crisis, and so the euro crisis. And yesterday, a general strike, I understand. This shows a marked loss of economic sovereignty. But there are no votes in complaining about the loss of economic sovereignty. The political centre holds and it imposes austerity. The sovereignty that I'm concerned about in this talk is legal sovereignty. And unlike the loss of economic sovereignty, in the UK, it's proving to be far more contentious. Now, a little bit about myself. By formation, I trained as a Euro lawyer, that is an EU lawyer, in the general principles of EU law, and in the substantive field of competition law. I'm an English barrister. And you might ask, so why it is have I come today? And the reason is because I want to know how to become the good lawyer, the autonomous human rights lawyer. Now, for a long time, I've been engaged in refugee law. And the reason for this is that refugee law is entirely governed by EU law. The Refugee Convention 1951 has been replaced, in Europe at least, by the Common European Asylum System. Comprises 3 directives and 1 council regulation. Now, what's fascinating for me is that the general principles of EU law are widely accepted in the fields of business and commerce. But in the fields of social rights and individual rights, EU law is still very, very contentious. And what's at stake here for the question of sovereignty is the loss of the governments of Europe's power to grant asylum or to withhold it. It used to be, asylum used to be at the discretion of the member states, but now it's a duty. It's a duty to third country nationals, that is aliens or foreigners, to give them refugee status if they qualify for it under European Union law. Now, this represents a marked loss of sovereignty on the part of the states, who pride themselves, in fact, they define themselves in terms of their ability to refuse entry to foreigners. So again, what does this have to do with the euro crisis? Well, you'll note that it is EU law which has brought about this change. And the second part of the title in my paper, The Crisis of Faith, there I'm talking about my own crisis of faith. And we're talking again about what it means to be an autonomous human rights practitioner. The British Constitution is famously unwritten. That means that politicians and the courts have a measure of flexibility over basic rights through sometimes what is known as the common law. Now, the common law is English judge-made law, and to give you an example of what it is, in the UK, the right to a fair trial is governed by judge-made law because the judges are considered to be specialists in trials. They don't, for example, consider themselves to be specialists in setting the minimum wage. Now, the European Convention of Human Rights has been enacted in the UK. There is specific legislation called the Human Rights Act. But our Parliament is not bound by the Convention on Human Rights, and the courts are bound only to take the judgments of the European Court in Strasbourg into account. They're not necessarily bound to follow the Strasbourg Court's decisions. So the European Convention, therefore, does not have constitutional status in the UK because it's not supreme or basic in the sense that new laws which don't comply with the Convention are not going to be struck down by the English court. EU law, on the other hand, is supreme, and the English courts must strike down domestic legislation which is incompatible with European Union law. I say strike down, but to save face, in the UK we say disapply. The fact is that an English barrister has to be diplomatic over his choice of words says something again about the highly contested area, which is the loss of British legal sovereignty to Europe. Now, you will note then that there are two strands of EU law. There's the human rights strand, which is dealt with by the Convention and the court in Strasbourg, and then there's the European Union law strand, which has its centre in Brussels and is dealt with by the court in Luxembourg. Now, I said I've touched on sovereignty twice. First, in relation to the loss of the sovereign power to refuse foreigners entry to the United Kingdom, where they qualify under EU law as refugees. And I've touched on the supremacy of EU law over our domestic law. So you'd expect that any complaints about the loss of sovereignty in the United Kingdom would be directed towards the EU, Brussels and Luxembourg. But instead, the vitriol is directed towards the Strasbourg Court and the European Convention of Human Rights. Now, this is odd, because as I've said, the Convention of Human Rights isn't binding. Now, to give you an example of this, a senior judge in the Court of Appeal, Lord Justice Laws, in a speech which he gave last week, entitled "Do Human Rights Make Bad Citizens?" quoted himself in a judgment he gave in 2003. And this is what he says: "In the present state of evolution, the British system may be said to stand at an intermediate stage between parliamentary supremacy and constitutional supremacy. Parliament remains the sovereign legislature. There is no text to which it must defer." And then in parentheses, he says, "I leave aside the refinements flowing from our membership of the European Union." So there you have a senior member of the Court of Appeal pretending that the UK has not curtailed its legal sovereignty in matters connected with European Union law. He leaves those matters aside. And then what he goes on to say about human rights is this: But at the same time, the common law has to come to recognize and endorse the notion of constitutional or fundamental rights. These are broadly the rights given expression in the European Convention on Human Rights and Fundamental Freedoms, but their recognition in common law is autonomous. So he is saying, in plain terms, that the Convention of Human Rights takes effect in the UK not because of Strasbourg, but because the English courts have adopted it. So to understand the complaint made by government in the United Kingdom concerning the Convention on Human Rights, you have to understand that it's not really, or that the complaint about Strasbourg is a proxy for a struggle with the English courts and the rights of the English courts to strike down government decisions. So we talked about judge-made law, common law, and the right to a fair trial. And we talked about the irony of the complaint in England that it's Strasbourg which is interfering unacceptably in the public life of the United Kingdom. There's a great irony in that Strasbourg has held that when it comes to refugees, they're not entitled to a fair trial. In other words, the famous Article 6, which governs all our rights to a fair trial, does not apply to foreigners. It does not apply to refugees. It does not apply to immigrants. And so the British government is pushing at an open door when it would be pushing an open door if it decided to ignore the rights of foreigners to refugee status and to deprive them of a right to a fair trial, because it's not guaranteed for them in any event under Strasbourg law. EU law, on the other hand, that is the Charter on Fundamental Rights and Freedoms of the European Union and the Common European Asylum System, does guarantee refugees a right to a fair trial. And so we return again to my own disappointment and my own crisis of faith in EU law. Why do the English courts refuse to accept the constitutional significance of EU law? And I think the answer is this, that the English court is in a battle for supremacy with the court in Luxembourg, the Court of Justice of the European Union, and the Strasbourg Court, the European Court of Human Rights. It's in a struggle to be the greatest protector of human rights in Europe. And the threat that EU law represents to the English courts is a loss of its own sovereignty. So we're not talking about the loss of parliamentary sovereignty, the loss of the power in government to make decisions for the country. The English courts are concerned about the loss of their power to decide on judge-made law. Now, that, of course, is something, in my view, which is very much to be regretted. But on the other hand, I can't talk about this subject without telling you also about the vigorous decisions of the Supreme Court in the United Kingdom, which set out to rival the highest protections given by the Strasbourg Court and the Luxembourg Court. So in 2010, the Supreme Court was the first court in Europe to recognize that it would be an offense against human rights and everything that we consider to be sacred in terms of our freedoms, to force homosexuals from Iran to return to Iran, where they would face persecution in the event that they were open about their homosexuality, on the basis that, well, they could jolly well live discreetly. In other words, it had been thought previously that if a homosexual were to hide his homosexuality, he should be forced to do so, and that would justify their return to a country such as Iran, where otherwise they'd face persecution. Now, that decision was in July of 2010 and represented a significant step forward in the protection of human rights. That decision has been followed now by the European Court of Justice in Luxembourg. On the 5th of September, the Luxembourg court made the same pronouncement in a case called Y and Z. So the English court can say that it was 2 years in advance of the Luxembourg court, the EU court, on this question. And now, on the 25th of July of this year, the Supreme Court in England has extended these protections further still. They held in a case which concerned Zimbabwe that the right to live free from persecution and the right not to have to hide one's sexuality in order to keep safe from persecution should extend to the holding of political beliefs. In other words, it would be contrary to human rights if we were to send people to Zimbabwe where they are politically opposed to the regime there in the expectation that they could keep silent about their political opinions and thereby keep safe from the persecution that would arise if they were to voice those political opinions. Now, that decision is enormously significant because it means, for example, that women around the world who come to the United Kingdom and who would be persecuted in their countries of origin if they were to complain about male patriarchy cannot be expected to go back and keep silent about female repression, because that would be contrary to their human rights and their right to human dignity to express themselves and their complaints free from persecution. Now, the reason why that is significant is because the Strasbourg court this year in a case called SF Sweden, talking about Iran and talking about political persecution in Iran, made the finding that the Iranian regime is so hell-bent on stifling opposition that anybody who in any way opposes the Iranian regime will risk ill treatment, detention, and torture. And so that's not just political activists, but anyone who in any way opposes the regime. At the same time, the Strasbourg court said, however, that the conditions in Iran were not such that anybody who comes from that country would be at risk of having their rights under Article 3 breached. Now, it seems to me that that's an impossible or an untenable position in light of the Supreme Court decision, which would say that if you are opposed to a regime, you shouldn't be expected to go back and keep silent. So look, that's what I wanted to say about the Supreme Court's pushing its head further, pushing ahead further than the Luxembourg Court and the Strasbourg Court. So returning again to my own dilemma, these vigorous displays of human rights protections by the Supreme Court in the United Kingdom give me, an autonomous EU lawyer, pause for thought, because they're extending protections that European Union law has not yet, where European Union law has not done so. And so should the good lawyer give up on EU law and return instead to the fold of domestic common law? Thank you. That's my question. Mm-hmm.